to introduce our moderator for the second panel. He is the Dean of the College of Law of the University of Batangas, Dean Hernando Perez Jr.
Good afternoon, everyone. For our second panel discussion for today, we'll be taking up the LEB model curriculum 5 years hence. For our first panelist, is currently the board member of the Legal Education Board, Attorney Manuel R. Rivera. Attorney Rivera will discuss the LEB model curriculum, how it was designated, and the rationale for the various subjects included. We will call up Attorney Rivera to sit in the panel. Our second panelist for this afternoon is currently the Dean of the College of Law of the University of the Philippines, Dean Danilo L. Concepcion. And our third panelist for this afternoon is currently the Dean of the Ateneo de Manila Law School, Dean Sedfrey Candelaria. Can we call on all the panelists, please, sit in the panel? Okay, so first off, Attorney Manuel Rivera will discuss the LEB model curriculum, how it was designed, and the rationale for the various subjects included. So, without further ado, Attorney Manuel Rivera.
Good afternoon, everybody. The topic that has been assigned to me is the LEB model curricula. Its design and its rationale. So, I will not pretend to discuss it with comprehensiveness. Just an introduction or the salient points of this LEB model curriculum. Next. The power of the LEB to prescribe the curriculum is in Section 4F of Republic 7662, Legal Curricula, the Law Education Curriculum. Possession of adequate legal knowledge, legal research skills, advocacy in the law, problem solving, decision making, and specialized legal ability. These are the more salient points of these competencies sought forth by the Legal Education Board. I would like to draw your attention to specialized legal ability. This provision, or this trait which the board seeks to inculcate in our law graduates, has been attained or is sought to be attained by the inclusion of more electives in the legal curricula for legal education. Next, please. Before the passage, or at the time of the passage of Legal Education Board Memorandum Number 1, which provided for the curricula, these were the existing curricula at the time of the passage, which is 2011. First, the UP College of Law curriculum, containing 141 units. Then the DEX Model Curriculum, passed in 1989. It had 132 units. The Ateneo Law School also had its JD curriculum, which was first issued in 1991, containing 156 units. So, the first and the second curriculum, or curricula, provided for LLB, while the third, introduced by the Ateneo, was the JD degree. These are the salient laws governing the LEB model curricula. I call it curricula because there are actually two legal degrees granted under our Philippine legal education system. The first one is LLB, and the second is JD. So, the Bible, or the manual, if you may say it regarding the curriculum, is Legal Education Board Memorandum Number 1, Series of 2011, Policies and Standards of Legal Education. For reference, let's call it LEBMO Number 1. Then I'd also like to draw your attention to LEB Memorandum dated September 3, 2013. Some of you might not be aware of this, but I will that this issuance also amended to a small degree LEB-PALS number 1. What was contained in this memorandum of the Legal Education Board of September 2013? Well, quite simple really. Remedial Law Review 2 and Civil Law Review 2, they have been reduced from 4 units to 3 units. So there might be some of you who are still confused. The curriculum here for Remedial Law Review 2 and Civil Law Review 2 has been reduced from 4 to 3 units. By the way, these are just minimum standards. Nothing will preclude a law school from prescribing additional units for these subjects, but these are the minimum standards. And because of the issuance by the Supreme Court requiring taxation law review to be taken up by refresher or retaker students, a new subject has been added in 4th year, 2nd sem, taxation law review. That is 2 units. The Philippine, our legal education system, I would like to draw your attention, that is a 2-degree law education system. There are currently 2 law degrees being issued or conferred by our law schools. The first, or the traditional one, if I may call it, LLB, from the Latin Legum Baccalaureus, or more commonly referred to as Bachelor of Laws. Then a recent innovation, first issued by the Ateneo Law School, the Juris Doctor degree, issued in 1991. In order to understand why were there two legal degrees granted here in the Philippines at the time of the issuance of LEB-PALS number 1, the dominant, I should say, it was practically the only law degree, except for the JD conferred by Ateneo, was LLB. So the Legal Education Board saw fit to retain the LLB, but also introducing the JD program. Now the JD program, as you know, is a fairly recent innovation which was created in the United States in response to calls that the legal degree actually is a graduate degree and not just merely an undergraduate degree. So in order to better understand this 2-degree system present in the Philippines, I would draw your attention to the traditional distinctions between the LLB and the JD. LLB is traditionally an undergraduate scholarly degree, as opposed to the JD, which is a professional graduate degree. Why is LLB traditionally an undergraduate scholar degree? LLB originated in England, and the training there for law was primarily not to turn out lawyers, but to turn out statesmen and philosophers. So the training there was in civil law and canon law, and the graduates were not expected to practice law, but they were expected to be statesmen, scholars, or philosophers. Common law, which involved the practice of law, was not taught in the law schools in England, but it was learned in the so-called Inns of Court. So it was a scholarly degree. Even in the United States, prior to the issuance of JD, the common observation was that the LLB degree trained more statesmen and philosophers rather than those who actually practiced law. In response to the scholarly or to the undergraduate nature of LLB, the JD degree was created. Now the JD degree is a professional degree. The purpose or the traditional purpose of the JD is to turn out practitioners, graduates who are able to practice law. So not just scholarly or the liberal arts training in LLB, but graduates who can actually practice the profession. So it's a professional degree. It is also a graduate degree, unlike the undergraduate degree nature of LLB. Why do we say it is a graduate degree? If you go to the second distinction, traditionally a college degree was not required for admission to the LLB program. For a time, even in the Philippines, a college degree was not required for admission to the LLB. There was the so-called Associate in Arts program, which was a 2-year program. The JD program, however, requires a college degree. Now, this is not a traditional distinction, but just to draw your attention to those countries where the LLB degree is predominant. In England, of course, Australia, India, Hong Kong, and Singapore. You notice these are the Commonwealth countries. They are under the influence. The JD is a fairly recent development. Until recently, only law schools in the United States offered the Juris Doctor. Starting about 1997, however, universities in other countries began introducing the JD as a first professional degree in law, with differences appropriate to the legal system of these countries in which the law schools are situated. Over time, in most countries except the Philippines and Japan, the distinctions between LLB and JD have disappeared, the curriculum for both being essentially the same. So it was really a matter, aside from the Philippines and Japan, the distinction between JD and LLB has disappeared. It was just a matter of semantics. They felt, those countries or those colleges which began issuing the JD degree felt that JD was the more appropriate term for a professional graduate degree. So whether to call it LLB or JD was a matter purely of choice, individual choice by the law schools concerned. Because as I've said, the curriculum is essentially the same for both LLB and JD. So for example, you go to Hong Kong. Although the dominant law degree issued in Hong Kong is LLB, there are some Hong Kong law schools which issue JD. Same with Australia and Singapore. In these countries, the dominant law degree is still LLB. But there are some schools there which are already offering the JD degree. Now let's go to the Philippine two-degree system, LLB and JD. Now in the Philippines, the difference between the LLB and the JD is a matter of regulatory fiat or classification as provided for in LEB-PALS number 1. If we will go to the comparisons, under the Philippine legal education system, both the LLB and the JD are considered as professional and graduate degrees with scholarly studies. That's why an LLB course has been considered by the CHED as a masteral course because it requires completion of a college degree. So in both LLB and JD, the college degree is required. The difference, however, this is the main difference between the LLB and the JD. No thesis is required in the LLB, while a thesis is required in the Juris Doctor degree. The definition of LLB, or Bachelor of Laws, is found in LEB-PALS number 1. It is a 4-year course that may be taken in semesters or trimesters. It is the basic degree in legal education and presupposes a collegiate or university bachelor's degree as earlier prescribed. So from this definition of Bachelors of Law in LEB-PALS number 1, we see the recognition that LLB is a graduate degree, it is a professional degree because it presupposes a collegiate or university bachelor's degree, taken in semesters or trimesters. Well, I was aware that the trimestral system was followed before in the De La Salle University, but it was abandoned in favor of the semestral system. Next. Now let's go to the definition of Juris Doctor in LEB-PALS number 1. It is likewise a basic law degree program that may run through 4 or 5 years at the option of the college or university. So there you see a difference in the length of time. The Bachelor of Laws is 4 years, while the Juris Doctor degree may be taken in 4 or 5 years. The evident reason for that is the greater number of units in the JD degree. So I would like to draw your attention to this phrase in the definition of JD in LEB-PALS number 1. Aside from all the subjects of the LLB curriculum, the JD curriculum shall prescribe additional subjects that may be taken as electives and require besides the writing of a JD thesis. So there are more electives to choose from in the JD rather than in the LLB, and there's also the writing of the thesis, which is a requirement for the grant of the Juris Doctor degree. Now let's look at the components of the LLB degree. It consists of 150 units. Number one, you have the so-called perspective courses, subjects that provide the students with a comprehensive approach to the law. Then core subjects, subjects that are considered indispensable to a lawyer's knowledge of the law. Elective courses. Well, this student is left. First, the school has the option of choosing from the prescribed electives what electives it will offer. Then the students will have the choice of choosing among those prescribed electives what they will enroll in or what they will take up. So this is the beauty of the electives. It's flexibility. It allows students, it allows the school to gear legal education towards the specific objectives, specific career objectives or desires of the student. Then practicum. Well, there is no thesis in the LLB. There is a practicum, but I draw your attention that the practicum requirement in LLB is merely optional. Unlike the thesis requirement or the apprenticeship requirement in JD, which is mandatory, the practicum requirement in LLB is optional. Instead of practicum, the law school or the law student may have the choice of taking up electives, additional electives under the LLB program. Then a legal research paper. A legal research paper may be assigned in the LLB curriculum to train students to write effectively and to research proficiently. I draw your attention to the word may. So unlike the writing of the thesis in the JD program, the writing of a legal research paper is optional. It may be assigned by the school to the student. Optional with the school, but not with the student. Once assigned, the student has to do the legal research paper. Let's go now to the Juris Doctor degree. It contains 169 units as opposed to the 152 units of the LLB program. Well, it's 169 because of the adjustment made by the LEB-PALS memorandum dated September 2013, which reduced civil law review and remedial law review from 4 to 3 units and added taxation law review. The net result being to increase what had been a minimum 168 units to 169 units. There are, like in the LLB, we have the so-called perspective courses and we have the core subjects. Then we have elective courses, and these are the requirements or the features which are unique to the Juris Doctor apprenticeship. As you know, apprenticeship will consist of 120 hours per semester. So this represents a significant investment of time on the part of the school and of the student. Then the JD thesis. This is not a requirement or this is not a feature of LLB, but it is a requirement of the JD program. Now, the requirement of a JD thesis is, if you might say, an innovation here in the Philippine legal education system, because in the American JD, the writing of a thesis is not required or is not mandatory. But here, when the program was introduced by the Ateneo Law School in 1991, the writing of a thesis was a requirement for the grant of the JD degree. Another feature of the LEB model curricula are the following subjects which have been upgraded or promoted from being electives to the status of regular or prescribed subjects. We have agrarian law and social legislation, human rights, natural resources and environmental law, and alternative dispute resolution. I think these are the reason for this is quite evident. These are subjects which every lawyer should know. especially environmental law with respect to the situation here in the field. Alternative dispute resolution, very important because of the evolving nature of legal practice wherein there's a shift to alternative dispute resolution rather than to litigation in resolving disputes or in resolving cases. Then human rights. I think with respect to the ASEAN, there was an initiative before, I don't know, I think Candelaria would be familiar with this, for the creation of a ASEAN Human Rights Center here. Now this is a subject which was added by the Legal Education Board as a required or a basic subject, and I highly recommend, or I highly encourage, or I'm very favor this introduction by the Legal Education Board of this subject, legal technique and logic. It is now a basic or required course. From the description in LEB-PALS number 1, it involves the features of legal technique and logic are syllogism, arguments, deductions. Then the logical organization of legal language and logical testing of judicial reasoning. In my experience as a professor and as a bar reviewer, I noticed that many of the failings of law students and law graduates are lack of training or grounding in logic. These are very important. Syllogism, deduction, and analogy, because at bottom, all legal reasoning is really deductive syllogism or analogical reasoning if it's reasoning from a decided case. This is a matter which was not imposed, really, not just imposed by the LEB, but by the Supreme Court itself. Because if you will read the guidelines in the bar examination, it says that the answer should state a conclusion and the applicable law. And the applicable law should be applied to the particular facts of the case. If you will analyze that, that is actually a deductive syllogism. So the deductive syllogism is being encouraged, or is actually, we might say, a requirement imposed by the Supreme Court upon bar examinees. Well, you might say here that, again, and I'm touting legal technique and logic, that I'm being bar-oriented, but no. Training in legal technique and logic is important not only for the bar examinations, but also for practice. For example, here in the curriculum description, it says logical testing of judicial reasoning. Practitioners or our law graduates could apply this in order to test whether judicial reasoning is sound in order to win on appeal. Judges themselves, in order to take care that their decisions will not be overturned on appeal, would do well to structure their decisions based on syllogism. So legal technique and logic is a very important subject. I would encourage the law schools to place additional emphasis on this subject. Next, please. Now, if you will notice, there are the so-called perspective courses. The description in LEB-PALS number 1 is subjects that provide students with a comprehensive approach to the law. What are some... They could not be termed, they are not really termed as indispensable to legal knowledge, but for the purpose of conferring upon students a comprehensive approach to the law. What are some examples of these perspective courses? You have philosophy of law, legal profession, problem areas in legal ethics, special issues in international law. Next. Why are there perspective courses both in the JD and in the LLB program? Because this reflects the fact that the JD and the LLB program are not only professional degrees, they are also scholarly degrees. So you might say a throwback to the English concept of the league of the baccalaureate of the Bachelor of Laws being essentially a scholarly rather than a professional degree. Next, please. JD thesis. Now this is the requirement for the issuance of the Juris Doctor degree, and it refers to an extended research work written under the guidance of an advisor or moderator upon completion of the academic units as may be required by an institution. In legal education, it is a requirement for the JD degree. So it has been institutionalized under LEB-PALS number 1 that no JD degree can be granted without the writing of a thesis. That would differentiate our JD degree from the JD degree in the United States, wherein the writing of a thesis is not a requirement. Next, please. The LEB model curricula are minimum requirements. So, it does not mean that nothing precludes. While a law school should comply with the minimum requirements, nothing precludes a law school from enriching or increasing the number of units. So a law school, for example, may decide that remedial law review 2 would be worth 4 units rather than 3 units. That is subject to the exercise of academic freedom of the law schools. But take note of this. Take note of this phrase. While the law school may design its own law curriculum for each of the degrees offered, each curriculum must comply not only with the LEB manual or LEB-PALS number 1, but must be in accord with required subjects in the bar examination in case of both the LLB and the JD degree. So this is a recognition of the inescapable fact that the bar examination exerts a significant influence on Philippine legal education. Next, please. So enrichment, as I've said, law schools may decide to add or to increase the number of units. Now, let us just run through the curriculum. I will not be discussing this in detail, just to show you. Now, the first year LLB, these are the subjects, 16 units and 17 units. Let's compare that. Next, please. Let's compare that with the first year JD. Going back, please. If you will, let's compare first year LLB. If you compare the first year LLB to the first year JD, there is no legal philosophy in the first year LLB. Next, please. Which is quite interesting, taking into account the consideration that it is the LLB degree, which is supposed to be the scholarly degree. Next, please. Then second year. If you will notice, alternative dispute resolution. This is what I find interesting. Alternative dispute resolution is a required or a core subject in the LLB. But in second year JD, next please. It is not. Although there are electives on alternative dispute resolution, which we will find in the JD degree. Next please. Then third year JD. Now, this is what is significant. The summer apprenticeship program consisting of 120 hours. You don't find that in the LLB degree. So it definitely represents a significant investment of time on the part of the student and of the instructors. So it could impact on their choice of whether to go LLB or JD. Next, please. Then the fourth year LLB and then the fourth year JD. So we have here the JD thesis in the fourth year JD. Next. So let's do a summary of the differences between LLB compared to JD content-wise. Before we had undertaken a distinction, we had studied the traditional, or we had seen the traditional distinctions between LLB and JD. Now let's go into a distinction or comparison based on the content. So LLB, 152 units. Well, it represents in itself a significant increase from the model, from the basic model law in 1989, which was only 132 units. Now it's 152 units. But JD is 169 units. So that's 17 units there. That is definitely a big difference in time and duration between LLB and JD. The next point of differentiation is on the percentage of bar subjects with respect to the total course. In the LLB degree, bar subjects represent about 81.58% of the total course content. While in the JD program, it's lesser, 72%. Well, of course, the reason for that is the greater number of electives in the JD program. Then, the duration of the course, LLB is supposed to be taken within 4 years. JD, the school has the option of 4 years or 5 years to complete the JD. So it might be more flexible for some students to take it up in 5 years rather than in 4 years. Then the writing of papers. In the LLB, it's a legal research paper, but take note that it's only optional. Then in JD, you have the JD thesis, which is mandatory. Number of electives. In the LLB, the required electives to be taken up by the student are only 2. Compare that with JD, where it is 16, more than 3-fold or 4-fold increase from the requirement in LLB. I think this represents this because of the consideration that JD is more practice-oriented than the to guide the students, to teach the students to practice law, to improve their competencies in the practice of law. Then electives / practicum. Now this is a unique feature of the LLB. A student may choose, or the school may choose between electives and practicum, 4 units. So you may have a situation where electives could comprise about 6. The required course may be 6 units of elective, or you can also have a situation wherein there might be no practicum taken up by the student because he can opt for electives rather than practicum. In JD, you have the summer apprenticeship, 4 units, but as I said, the summer apprenticeship program is about 120 hours per semester. Next, please. Curricular content. Now, these are some of the distinctions in curricular content between LLB and JD. In a matter of nomenclature between administrative law, it's just the inclusion of public officers, but alternative dispute resolution is a core subject in LLB, while it is elective in JD. Public international law. Aside from public international law, it was only, when it was 3 units in LLB, it became 2 units in the JD course, but there's an addition of special issues on international law. And here, legal ethics. So there is more trust for legal ethics in the LLB curriculum rather than in the JD curriculum. Next, please. Now, as I've said, well, JD is supposed to be more scholarly than LLB. I think this is addressed by these subjects which are required in JD but are not required in LLB. Introduction to law, legal profession, and philosophy of law. Then in LLB, you have legal counseling and social responsibility. It's a required course in LLB, but it's merely a 1-unit elective in JD. Next, please. Now, what would be the guidelines, or what would be the factors which would lead a student to choose one degree over the other, or which would make a school decide to offer one degree over another? So, to my mind, at least, this is strictly my opinion, but it's based on my analysis of the traditional distinction and the LEB-PALS number 1, these are what I perceive, and also from interviews with some of the deans and law students, these are the factors which I perceive to be critical in making a student choose either LLB or JD. LLB, it's a linear curriculum. As we have said, it's only 152 units as opposed to JD, which is 169 units. Now, although LLB curriculum is, we could say, linear, JD has more electives. So for a student who might seek a more well-rounded legal education, he can opt for JD rather than LLB. I think this is also a very important factor, cost efficiency, right? So the LLB course would be less inexpensive than the JD course because of the additional time and units. Now, for students who have a pragmatic approach, who are, I think, and there are quite a lot of students on this aspect, whose main concern is just passing the bar examination and getting their certificate to practice law, they might prefer the LLB degree over the JD degree. Why? Because it has more focus on bar exam preparation rather than the JD degree. I'm not saying that the two are not bar exam focused. We could say that they are, but we could say also in a sense that there is more focus on bar preparation in the LLB because a student here will be better able to prepare, to at least to his thinking for the bar examination because he does not need to take up additional elective courses. On the other hand, choosing the JD, a student may feel that it has more focus on practice or skills acquisition because of the increased number of electives. So the student who feels that he should get a more well-rounded education, a better training or skills acquisition, might opt to choose the JD over the LLB. Then added prestige and international branding. There is a perception that the JD is of a higher, if I may call it, pedigree than the LLB degree. And international branding. We learned that the dominant law degree in the world is still the LLB degree because the JD degree is dominant only in the United States or in Canada. However, because of the domination by the United States, by the big US law firms of international and global practice, there is added prestige to the JD degree. So a student who wants the added prestige or who wants international branding because he might opt to go to international practice might choose the JD degree over the LLB degree. Well, this perception itself was from a professor emeritus of the Osgood Hall Law School at York University, which offers the JD, and I think from which Justice Brion took his Master's of Law. This is his statement: the JD is now seen as more prestigious than the LLB. So it's not just us Filipinos, but a leading Canadian professor. So this statement could engender what we call a JD&B for those of us who have the LLB degree. International recognition. We cannot ignore the dominant influence of the United States, not only in culture, but also in international legal practice. International legal practice, as you know, is dominated by the big US law firms. Big US law firms, big American lawyers. Right? Like for example, even in our arbitration case against China, our lead counsel was an American. So those students who might want to go into international practice may feel that the JD degree would offer them better prospects in this regard rather than the what some might call the more insular LLB. Now, those of us who may want, or who, like me, who suffer from a JD&B might choose to avail of what we call a upgrade. The LEB-PALS number 1, section 15, itself provides for an upgrade or a ad Yundem degree. Where a law school, level number 1, section 15, where a law school offers the JD curriculum, a qualified LLB graduate who is a member of the Philippine Bar may be admitted to teach in the JD course and may wish to consider the privilege granted under section 56.0. And additionally, they may choose to avail of the so-called degree ad Yundem to, if I may call it, to upgrade to the JD. What is the degree ad Yundem? We find that in section 56. Where the law school offers the JD degree, it may confer this degree upon its faculty members who deserve that degree because of renown and scholarship, as evidenced by their authorship of law books, legal articles, monographs, or treatises published in reputable local and or foreign law journals. So that might discount those of us who like to publish articles in the web, because I think the best publication is by a reputable publisher. But if you notice the degree ad Yundem, by the way, degree ad Yundem from the Latin ad Yundem gradum, meaning an equal degree. It's a degree of convenience which a law school offers, which a law school granting the JD degree offers its faculty members. So the degree ad Yundem here, if you notice, could be available only by those teaching or by faculty members. How about those who are not faculty members? Do they have the option of upgrading to a JD degree? We will see later on that they could. In the United States, where there is essentially no difference between the LLB and the JD degree, the difference being merely a matter of semantics, the Harvard Law School, upon the issuance of the JD degree, said that it would make available the JD degree to its LLB graduates upon application, retroactively. So an LLB graduate of the Harvard Law School may apply to be granted the JD degree, and it would be granted. There would be no requirements there, just merely an application, because the curricular content between JD and LLB is the same. And whose primary concern is to pass the bar examination may opt for the LLB. He passes the bar, then later on, his practice involves a lot of dealing with foreign clients, and he feels that a JD course may be better suited to him. So he could take on a short course in order to obtain the JD degree. I was talking with Dean Joan Largo, and she said that they do have such a program. So, by the way, are there law schools which are offering both simultaneously the LLB and the JD program? Can a law school do that? Yes, there's no prohibition in LEB-PALS number 1. So, a law school may choose to offer both the LLB and the JD program, targeting different sectors of the market. The LLB program would target those who may have a more cost-efficient, or more cost-efficient approach, so they might choose to go to the LLB. On the other hand, those who want to go to international practice would opt to go to the JD program. So Dean Largo said that those LLB graduates in San Carlos, they want to upgrade, they may upgrade to the JD course. I also asked her, what if I am a graduate of another law school? Can I enroll in University of San Carlos for additional units so that this would be credited for a JD course? And she said that this would be possible. So those of us who are suffering from JDNB may choose to enroll in these law schools offering the upgrade. Okay, now this list of recommended electives. Just go through it briefly. Banking law, I recommend this, general banking, right? Bankruptcy laws, mergers and acquisitions. Humanitarian law in armed conflicts, there might, choice of electives may depend in the situation or the location of the law school. So those law schools which in areas where there are armed conflicts may choose to offer this. indigenous rights law. Those in the provinces can offer indigenous rights law. As Dean Divina earlier said, the Blue Ocean Strategy, this could be a niche for those law schools. Now, I would like to end by saying that the LEB model curricula is, in a sense, a work in progress, and especially insofar as the electives component are concerned. The LEB recognizes that fine-tuning and refinements are still necessary, so we are open to suggestion from all stakeholders in legal education, from the professors and the dean, on how to further improve and fine-tune the LEB model curricula. So, thank you for your time.
Has the autonomy to design its curriculum, not being under the jurisdiction of the Legal Education Board. Dean Concepcion will discuss the UP Law curriculum and the various curricular innovations UP Law has made through the years. So, and I present to you our esteemed colleague, Dean Danilo Concepcion.
Thank you very much. The first innovation that UP introduced in legal education is the core elective curriculum. There is a core of basic subjects that the student must finish, complete, pass in the law school. And then there are electives, a menu of electives from which a student may choose a certain number of elective units for him to be able to graduate the basic LLB course. Now, why did we do this? It was done during the time of Dean Irene Cortez. That was not the curriculum before her time. During the time of Dean Abad Santos, that was not our curriculum. It was done because the number one law school in the country must pace itself with its counterparts in the other parts of the world. We have to be at par with the curriculum of those schools. It came at a time when new areas of practice have evolved. New areas of practice which were not part of the old curriculum. And somehow, we have to accommodate those courses, new areas of practice for the students to learn, and so that they become competitive in the market. The number one stumbling block that we encountered in making this new curriculum effective is the bar examination. Over the years, the Supreme Court had added many subjects in the coverage of the bar. Alam ba ninyo na before 1960, wala namang tax sa bar exam. Pero dinagdag nila ng dinagdag yan. Dadami pa siguro. Kasi marami namang areas, no? There are new areas of practice which have evolved. And if you predict how the Supreme Court will react, mukhang isisingit na naman nila yon. Example, the intellectual property. Dati yung intellectual property, hindi naman halos yung kasama sa curriculum. Pero lumago yung intellectual property, lumaki yung practice. Ano ang naging reaction ng Supreme Court? Ay, isama yan sa coverage ng bar. lumalaki yung coverage ng bar, nauubos yung oras ng estudyante para pag-aralan yung mga subjects na covered ng bar. Wala nang natira doon sa estudyante na oras para mag-aral ng ibang mga kurso. Kami naman sa UP, mayayabang kami. Sabi namin, kaya natin yan. So anong ginawa namin? Hinati namin yung aming mga subjects into 2. Yung tingin namin ay dapat na malaman, mapag-aralan ng estudyante before he graduates, ginawa namin core. Okay, halos kalahati yun. At i-re-up naman namin yung kalahati para maging electives. Marami doon sa aming mga electives mga bad subjects. So ano nangyari? Graduate ang aming mga estudyante, tapos nila yung kanilang core subjects, pero doon sa kanilang electives na pinili, wala doon yung mga subjects na covered ng bar. Naniwala ba kayo na meron kaming mga estudyante na graduate na hindi kumuha ng land registration? Kasi yung land registration ay isang elective sa UP College of Law. Lahat ng bar review subjects ay ginawa namin elective. So gumagraduate ang aming mga estudyante na hindi kumuha ng isang bar review course. Bakit? Mayabang po kasi kami. Ang tingin namin, makakapasa yung mga estudyante namin sa bar. And besides, we did not put much emphasis on the bar. Hindi po kami bar-oriented. Anong kinuhang estudyante, anong kinuha ng aming mga estudyante? Ay, nag-offer po kami ng napakadaming electives. Kung gusto mo ng economic law, pag-aaralan mo yung WTO, meron yan. Kung gusto mo ng advanced labor standards law, ay meron kami yan. Kung gusto mo ng international business transactions, ay meron kami yan. Advanced intellectual property, name it, we have it. Cyber law, meron kami yan. Meron kaming mga estudyante na nag-masters abroad, yan ang kanilang in-specialize, ay tinuturo yan. Pero hindi nagbago ang bar eh. So anong nangyari? O, nakita naman ninyo. Di bumaba ang performance ng aming mga estudyante sa bar. At first, anong reaksyon? Ay, don't worry about the bar. Don't focus your energy on the bar. Ang problema, kung babakasa ka sa bar, hindi ka naman makakapag-practice. Galing-galing mo, dami mong pinag-aralan, hindi ka naman makapractice. Okay. Bakit namin, isa pang rason, why did we divide our curriculum into 2? Kasi kapag finre-up natin yung kalahati, mag-i-specialize yung estudyante. Doon pa lang sa law school, nag-i-specialize na siya. At kung maaprubahan yung ating proposal to reduce the coverage of the bar, di ba? Inaprubahan na natin yung proposal ngayon eh. Nakapending pa lang sa Supreme Court. Kaunti na lang yung pag-aaralan niya para pumasa ng bar, then ma-devote niya yung kalahati ng oras niya para mag-specialize. In one of the faculty meetings of the college, when I was discussing this proposal to reduce the coverage of the bar, one of the faculty members raised a comment. I would not classify it as an opposition. He just raised a comment. She is a labor faculty. Sabi niya, Dean, kailangan ng ating mga workers ng labor lawyers. Ang dami-dami nating workers who need protection. Pag tinanggal mo yung labor law sa coverage ng bar, ay baka mawalan ng mga abogadong magtatanggol sa ating mga manggagawa. Ang sabi ko naman sa kanya, on the contrary, tignan mo, ngayon, pinapag-graduate mo ang isang abogado, 2 subjects lang ang kinukuha niya sa bar for labor law. Ano yon? Labor law 1, labor law 2. Yun lang ang kinuha niya. Pero the moment na ifinri natin yung kalahati ng kanilang panahon at ang estudyanteng ito ay gusto mag-specialize ng labor law, aba, yung kalahati na yon, i-devote niya na yan sa lahat ng labor law, advanced labor law courses. Alam ba niyo kung saan niya pag-aaralan yan sa UP? Meron kaming School of Labor and Industrial Relations. Masters yun. Doon siya kukuha ng lahat ng advanced labor courses at makikredit doon sa kanyang course. Ano ang kanilang kinukuha? Mga antiquated laws. Ano unang-una kong ginawa? Nung ako ay naging dean. Kasi po, bumagsak ang aming performance. I have to do something about that. Hindi ba kung hindi na kami ang #1 law school, nakakahiya naman. Alam niyo kung anong una kong ginawa? Sinuspend ko lahat ang offering ng courses na hindi ba related. And in a matter of 1 year, nakita ninyo ang result. Just 1 year na hindi ako nag-offer ng elective na bar-related. Kita na agad nila ang diferensya sa results. Kasi yun kung pumasok ako, yung mga 4th year doon, wala na kayong elective na hindi bar-related. Inubliga kong kumuha ng mga bar review courses. In a year's time, kita na nila. The day the bar results were released, top yung aking mga estudyante. Merong affair ang WILOC. Ito po yung asosasyon ng mga women lawyers who graduated from UP. Since miyembro yung aking misis doon, yung commander-in-chief ko, pinapunta agad ako doon sa kanilang meeting at ako'y kinongratulate. I told them, nakikita lang ninyo yung ibabaw, pero hindi nyo nakikita yung ilalim. I will succeed in producing top-notchers. But top-notchers of what? Sila ay mahuhusay ng mga domestic lawyers na nag-specialize sa kalahating antiquated laws. Hindi sila prepared to do global practice. So ang sabi ko sa kanila, I cannot do this for a long time. So what's the solution? The first solution is the reform of the bar exam. Hindi inuupuan naman dun sa Supreme Court yung ating proposal to reduce the coverage of the bar. Alam ba niyo sa Amerika, na ang coverage ng bar ay 3 subjects lang? Hindi sila ini-examine sa lahat ng pinag-aralan nilang kurso. Dito sa Pilipinas, political law. Ilan ang kasama sa political law? Public international law, Bill of Rights, yung constitutional law and form of government, law, public officers, local government, administrative law, in public international law. Doon lang, 8 na eh. Dito lang sa Pilipinas, 1 buwan ang exam. But anyway, tapos na yun, napag-desisyonan na natin yun. Meron pa kaming isang innovation na inintroduce sometime in the late 60s. Ito po yung clinical program. Ito yung clinical education. Alam nyo kasi ito, ang history nito, nag-open kami ng Office of the Legal Aid. Ang talagang purpose lang naman ng Office of Legal Aid, mag-provide kami ng libreng legal service doon sa mga kapuspalan na nangangailangan ng legal service. Ay dumadami yung kliyenteng pumupunta roon. Ay in-involve namin ang aming mga estudyante. Napansin namin, maganda pala na ang estudyante na i-expose na doon sa practice, estudyante pa lang. So ginawa namin part of our curriculum. Kung sa Legal Education Board model, ito'y optional, ay sa UP College of Law, mandatory ito. Ito ba'y bago? Ay, hindi po bago ito. Ito po ay kinopya lang din namin sa ibang bansa. Alam niyo sa Inglaterra, sa UK, ang isang estudyante, direct from high school, pumupunta ng law school, mag-aaral ng 3 taon. Classroom component yon. Yung 4th year doon, apprenticeship yun. Lalabas ng eskwelahan yung pupuntahin dun sa, kung gusto niya maging barrister, pupuntahin dun sa lawyers in, yung bar association. Kapag sinertipikahan yun after 1 year, na siya pwede nang mag-bar exam for to become a barrister, tsaka lang makaka-bar exam yun. If he wants to be a solicitor, then he will apprentice with the law societies. And if he is certified by the law society that he is now ready to take the exam, that's the time that he will sit in the exam. Pag pumasa siya, magiging solicitor siya. Alam po ninyo, ako naniniwala na ang pag-aaral ng batas ay parang pag-aaral ng medisina. Ang isang nag-aaral ng medisina para maging doktor, para siya ay maging mahusay na doktor, kinakailangan siya ay mag-aral ng on-the-job training sa isang teaching hospital. At mas maraming kaso ng sakit ang hinawakan niya at na-expose siya doon sa teaching hospital, mas humuhusay siya bilang isang doktor. Kaya mahuhusay ang produkto natin sa UP, sa PGH. Why? Ay tambak ang kaso ng may mga sakit doon na pag-aaralan nila. Tambak-tambak. Sa aking pananaw, ganun din dapat ang pag-aaral ng batas. Kinakailangan na ma-expose natin ang estudyante bago pa man siya graduate dito sa mga kasong ito na kanilang hahawakan, katulong yung mga lawyers at mga professors nila. Nasa ganon, mag-merge yung kanilang theory na pinag-aralan sa classroom doon sa practical aspect na kanilang mai-encounter sa practice. Maso-shorten natin ang training na kailangan ng estudyante para siya maging isang practicing lawyer pagpasa niya sa bar. Ika nga, we will make him hit the ground running. Ngayon, meron akong proposal. Sumulat ako sa Board of Regents. Sabi ko sa Board of Regents, alam niyo yung Office of Legal Aid, ang talagang nakalagay doon sa aming by tradition, kasi ako'y naghahanap ng papel, wala naman akong makita. By tradition, ang tinatanggap lang namin, indigent clients. Ano naman ang kaso ng indigent clients? Yung indigent client ba, magkakaroon ba ng succession case yun? Walang pamana yun. Meron bang corporation problem yun? Wala. Labor ang problem nun. Okay. This nature of our legal aid has restricted the type of cases na aming hinahawakan. So ako ay sumulat sa aming Board of Regents, binabago ko na. Sabi ko, tatanggap na kami ng lahat ng klase ng kaso. At kung yung kliyente namin ay may kakayahang magbayad, ay sisingilin na namin. Kaya meron na kaming pay ward, charity ward. The UP College of Law will now operate a full-fledged law office. At meron na kaming building. Itidonate po ni Miriam Defensor Santiago. Ando na, tapos na. We will be hitting 2 birds with 1 stone. Alam nyo kasi yung aming mga estudyante, para sila'y ma-expose sa maraming types of cases, pinapadala ko na sila sa OSG. Pinapadala para doon sila mag-practicum. Ang tawag namin internship. Pinapadala ko sila doon sa OGCC para ma-expose naman sila sa mga corporate cases. Doon sila nag-i-internship. Pinapadala ko sa ombudsman. Okay, pinapadala ko sila sa mga law offices with whom the College of Law has memoranda of agreements. Abay, sabi ko yung mga estudyante ko, papalabasin ko pa, hindi, dito na. Ako na ang gagawa ng law office dito. At lahat ng kaso, amin na ang tatanggapin dito. Okay. Pangalawa, ang mga faculty namin, magpa-practice na dun. Di ba? Kasama na sila. Merong team, comprised of an active practitioner who may not be a faculty, o merong constitutional issue, o yung constitutional lawyer, part ka ng team dito, kasama ka dito, pa-practice na tayo. Okay, now, anong effect nito? Yung faculty ko ay hindi lang armchair, hindi lang siya theory. Hindi mo masasabi, theory ka lang, sir. Ay, hindi, nagpa-practice ako. Okay, nagpa-practice na siya. So, bubuksan na namin itong clinical program namin. Pero ang isang pinakamalaking problema ang hinaharap ngayon ng legal education ay itong impact ng K-12. Alam niyo nung araw, panahon ni Justice Victorino, ay bata pa naman si Justice Victorino, hindi ko naman sinabing matanda. Ang pre-law nung araw, 2 years lang associate in arts. Okay. Pagka-graduate nila ng 2 years ng associate in arts, ay pupunta na sila sa law school, 4 na taon. Okay, di 6 na taon, lawyer na siya. Pero sapagkat tayo mga Pilipini, gaya-gaya sa Harvard, nung nagbago ang Harvard, sunod din tayo. Ang ginawa ng Harvard, 4-year baccalaureate degree preparatory. Plus 4 years, di 8 taon na, no ha? Plus 1 taon ng bar review, 9 na taon. Ano ang edad ng isang estudyanteng gumagraduate ng high school before the K-12? 17. 16, 17. Palagay mo na 17. Plus 9 years, 26 years old. 26 years old. General practitioner ngayon lang yan. Ngayon, K-12, ay dadadagan mo pa ng 2 taon. Ang isang abogado ngayon, 29 na. Baka hindi pa lawyer. Kasi pang titikto pa ng bar. 29, wala pang specialization yan, hindi pa nakakapag-practice yan. We will be producing old lawyers. Tanda na. At yan, hindi na mag-i-specialize halos yan. Bakit ka mo? 29 na, may asawa na yan, may pamilya na yan. Magmamasters pa yan. Kaya, Justice Larry, kapag ni-require niyo talaga na mayroong master's degree ang isang profesor, ay magsasara ang mga law school. Matanda na yan. May pamilya lang aasikasuhin yan. Hirap na hirap ang makagraduate ng law. Ngayon, ano ang ating solusyon dyan? Because of the K-12. Ito ang ipopropose namin. Parang internet. Okay. From high school, diretso ka, pero gagawin na lang natin 6 years. Okay? Gagawin natin ladderized pa. Kapag natapos mo yung first 4 years, kasi nakadesign na yung curriculum dun sa law eh. That course is really a preparatory course for a JD. Okay. From high school, diretso ka doon sa preparatory course na yon. Pagkatapos mo ng 4 years doon, dahil preparatory course talaga yon, pwede ka nang i-grant ng isang degree. Kapag hindi ka on legal management, pwedeng legal management ang degree mo. After 4 years, may degree ka na. Pwede tayong mag-create ng another degree, Bachelor's in Jurisprudence. Diba? Para mag-JD ka, another 2 years. Okay. Another 2 years yun, JD ka. So, ang JD will be 6 years, but direct from high school. Okay, that's one proposal. Anong equivalent niyan? Ang equivalent niyan ay yung 2 years associate in arts, sana, at saka yung 4 years. Kaya lang, naging 4 year din yan dahil meron kang dinagdag na 2 years dun sa K-12. Yung proposal ni Justice Romero ay talagang straight 4 years lang. Okay, wala nang preparatory. Straight from high school, diretso ka na sa law, 4 years, LLB ka. Sir, paano kung kamukha ko? Ako ay engineering. Ang aking pre-law ay engineering. Paano ako maglolo? Ay, ganun din. Di ba? Pagka bago ka mag-law, engineer ka, okay, lahat ng subjects na wala ka, doon sa preparatory na yun, kukunin mo muna yun. Pag natapos mo lahat yung subjects na nasa preparatory, at saka ka palang papasok doon sa sa 2-year para mag-JP ka. Doon naman sa 4-year na yon na preparatory, ito nandun yung logic na sinasabi ni Commissioner. Naalala ko tuloy yung sinulat ni Oliver Wendell Holmes. Logic has never been the life of law. It's experience. I don't know if it will fly. This proposal will fly. Ito kasi, kung ako masusunod, ang proposal ko talaga, 4 years direct from high school. Naging naka-6 na siya dyan eh. Okay. Pero sabi sa akin nung iba, anak ko siya masyadong drastic yan. Gawin muna natin 6. Hanggang kailan? Ilang taon tayo magsi-6, tapos saka tayo magpo-4. Hindi, 4 na natin ngayon yan. Instead of requiring master's degree para magturo, the UP College of Law, when the 4th Bonifacio campus opens next year, will open faculty development training program. Kung gusto nyo nang maipadala yung teacher ninyo para magtuturo ng tax, ay intensive yun. Tuturuan namin gumawa ng syllabus, i-refresher namin yan sa tax. It will be a continuing school. Bibigyan namin yan ng certificate. Ayun, baka pwedeng gawin ng LEB for tax. Kung tax lang ang ituturo niya, okay na yung certificate. Okay? Of a proficiency in tax, whatever you call it, in tax. And that certificate will be good only for a certain period kasi kailangan niya mag-update. Okay. Diba? Kailangan mo mag-update. Okay, so ang ipopropose ko naman ay yung continuing education for law faculty. Okay. Which can be equivalent compliance for the MCLE. Pero sa halip na MCLE, teacher dito na natin ilagay sa puro pagtuturo. Kasi ngayon, kapag ka puro pagtuturo lang yung kinuha mong MCLE, hindi ka papasakay Pardo. Hindi disallow ni Justice Pardo. Pero baka pwede natin i-work out, no? With the Supreme Court. Anyway, I sit in the Bar Matter and MCLE Committee of the Supreme Court. Okay, so that's all. Naging masama ang experience namin. Kino-correct namin, but the correction is simply temporary. We cannot go on like this for a long time. At sa aking palagay, dahil gumaya sa amin ang Ateneo, kaya ganoon din ang problema ng Ateneo. Kaya alam na ni Vincent kung anong gagawin niya. Okay, thank you very much.